Hello, and welcome to another episode of Virtual Legality. I'm your host, Richard Hoeg, managing member of the Hoeg Law business law firm of Northville, Michigan. And today, as you can see on your screen, we're going to talk about Virtual Legality fan favorite, Microsoft. And in this particular Reuters article, the fact that President Trump has said that Microsoft is in talks to acquire TikTok. Now, I have some reservations about this story, some concerns about the way it's been reported in the various places that I have seen online. And that's the reason that I've made this video today. But before we can get to that, let's see what the reporting actually says. First, Reuters says U.S. President Donald Trump told reporters on Monday, so this is about a week ago, that Microsoft is in talks to acquire TikTok and that he would like to see a bidding war over the app. Microsoft declined to comment, which isn't a big surprise for these big corporations. They don't love to comment on these things, but it is worth noting that Microsoft itself has not said it's interested in buying TikTok as of this point in time. We basically have a statement from President Trump to reporters that Microsoft is interested, and we're going to talk about why that might be in President Trump's best interest over Microsoft's. TikTok, continues the article, which has about 170 million American users, was briefly taken offline just before a law requiring its Chinese owner ByteDance to either sell it on national security grounds or face a ban took effect on January 19th. And that's only one sentence of this article, but it really is the most important piece of this entire story, and there's a lot to unpack there. So let's talk about that law, the ban, and what President Trump has done about it. So looking at the law, we see it's called the Protecting Americans from Foreign Adversary Controlled Applications Act, which really just rolls right off the tongue. We're going to call it the TikTok ban, probably in further references in this video. But suffice to say, what it does is prohibit the support mechanisms for an application that is made by a foreign adversary, right? So in this particular case, China, through ByteDance, is deemed to control the TikTok application, and this law says it shall be unlawful for an entity to distribute, maintain, or update a foreign adversary-controlled application by carrying out in the United States services to distribute, maintain, or update such controlled application by means of a marketplace, etc., providing internet hosting services to enable the distribution, maintenance, or updating of such foreign controlled application. So what we saw on January 19th of this past year is a ban that took effect primarily through the network infrastructure that supports TikTok. You saw it from the App Store. You saw it from the various places that you might otherwise access TikTok through your iPad, your phone, or otherwise. And they said, we are taking it down. Why? Because the penalties for this are pretty extreme. The enforcement of civil penalties for this particular law are that an entity that violates subsection A, and again, we're talking about Apple, we're talking about Google here, we're talking about infrastructure support for what is deemed to be one of these evil applications like TikTok, shall be subject to a civil penalty in an amount not to exceed the amount that results from multiplying $5,000 by the number of users within the United States determined to have accessed, maintained, or updated the foreign adversary-controlled application as a result of such violation. So one of the reasons you saw this ban go into effect immediately on the date shifting over to January 19th was that Apple and other network infrastructure providers looked at this and said, well, that's a lot of money. You talk about 170 million potential American users for this application, $5,000 per user. We don't know if this is going to get enforced because it wasn't enforced by the Biden administration on its last day in office. Trump had already signaled that he was unlikely to enforce it on his first day and on in office, and we'll see that he is in fact not enforcing it right now as part of this video. But those on the outside looking in that aren't in control of the White House, don't know what's going to happen, say it's better to be safe than sorry, and we are not going to allow you to access TikTok because we don't want to get nailed by all these huge penalties for otherwise providing it to you. Now, the other aspect of that is it is performative in some respects. If you don't like that this law was put into effect, if you don't like that this ban exists, it does appear that ByteDance, TikTok, and other companies in the ByteDance family had a significant desire to show you how much pain would be inflicted upon you if you're an American citizen by virtue of this law. And so on that particular morning, a lot of stuff went down. A lot of stuff was taken offline, including things that were clearly not designed to be hit by this particular act, like the Marvel Snap card game on your phone. But you can also be sympathetic with those providers that say, hey, look, this law was just written this past year. We don't know what's going to happen from here on out. This is a lot of money for us to play with. It's our fiduciary duty to our shareholders to not play with that money if we can otherwise just knock down access. And so that's what we saw that morning. But you might also remember that the last time I talked to you about this particular topic in TikTok versus the US, I said I didn't think that this law was likely to survive because I thought it was a bill of attainder, an unconstitutional bill of attainder under United States law. And if we aren't familiar with that term, I don't blame you. But a bill of attainder, as described by the Cornell Law School in their kind of treatise piece here, says it's a piece of legislation that declares a party guilty of a crime. Bills of attainder allow the government to punish a party for a perceived crime without first going through the trial process. In the United States, bills of attainder are unconstitutional. The constitutional ban on bills of attainder works to uphold separation of powers by preventing Congress from assuming the functions of the judicial branch, right? We have these three branches of government. We have the Congress that writes the laws. We have the executive, the president, that sees them enforced. And then we have the judicial branch, the court system, that says what the law means. And in a criminal kind of proceeding, says whether or not someone is guilty of violating a law. Judges, right? That's what judicial means. That's where judgment comes in hand. And if Congress can just say, all right, all murders are illegal, that's fine. But if they also say, and we determine that Bob is guilty of a murder, and so he gets all the penalties without a court of appeals, without a trial process, without any due process under the Constitution, then we've got a problem. And if we look at this particular law, we see what it applies to. A foreign adversary controlled application means any of these technological applications by any of ByteDance, TikTok, a subsidiary of ByteDance or TikTok, an entity controlled or owned by ByteDance or TikTok, or more generally, a covered company that is controlled by a foreign adversary as determined by the president to present a significant threat to the national security of the United States. So what is happening in this law is that they've made the no murders provision here. You are a covered company if the executive determines that you present a significant threat and you give public notice, you make a public report to Congress, you do these various other things under the law. But also, we are determining on its face that ByteDance and TikTok would fall under these categories, and you don't get a say in it, Mr. Executive. And so I had said that I felt that this was a bill of attainder, but as I often say in this space, reasonable minds can differ, and the reasonable minds on the U.S. District Court that saw the first version of this case said, no, it's not a bill of attainder. Now, I disagree with this provision. We're going to talk about it as part of this video, but I disagree with this argumentation, and I'll talk about why. They describe the argument that TikTok makes as follows. TikTok claims the act is a bill of attainder and therefore prohibited by the Constitution. The government responds that the bill of attainder clause does not apply to corporations, and that in any event, the act does not constitute a legislative punishment. We agree that the act is not a bill of attainder, and that's how these decisions are always written. We tell you up front what we decided, but then we're going to explain our reasoning. A law is a bill of attainder if it, 1, applies with specificity, and 2, imposes punishment. Well, it's pretty clear that it applies with specificity. We're not even going to see them discuss that because TikTok and ByteDance are named right in the law. So the question must be, does this law impose punishment? It says you cannot support this application. If you do, you're going to be fined to death. So we're effectively going to ban access to this application in the United States. Is that a punishment for purposes of this argument? Because the act applies with specificity, that's all the court's going to say about it. This claim turns on whether the act can be fairly deemed a punishment. We conclude essentially that it does not. Before turning to the tests, however, we briefly address the government's threshold argument that the bill of attainder clause does not apply to corporations. This is a silly argument. When you are prosecuting a case like this or defending a case like this, you throw out all the arguments you can very often so that the strongest one, whatever the court deems to be the strongest, is on the wall as being thrown out by you because you don't know what is going to actually work for them. But the U.S. government saying corporations cannot be subject to a bill of attainder was really never going to play. In other cases, as this court says, we have assumed without deciding that the clause applies to corporations, but emphasize the differences between commercial entities and persons need to be considered. We take the same approach here. To determine whether a law constitutes a punishment, we analyze whether the challenged statute falls within the historical meaning of legislative punishment, the historical test, whether the statute, viewed in terms of the type and severity of burdens imposed, reasonably can be said to further non-punitive legislative purposes, the functional test, and whether the legislative record evinces a congressional intent to punish, the motivational test. So they've got these three tests. If you look at this, say, where is this in the law? Where is this in the Constitution? The answer is it isn't in there. If you go to law school, you'll see a lot of these things happening from the court side, but the court makes a lot of rules and kind of rubrics that they determine these things on. They make tests like this, then say this is what we're going to decide it based on. And that's how our presidential system works in the United States. It's maybe not the cleanest way to evaluate things like constitutional questions, but it is the way that we do it. So they adopt this test. It's adopted years and years ago. It's the precedent the court will follow. And they say this isn't going to fall under any of these particular categories. Now, I look at this and say, this sure seems like you are preventing me from conducting business that I want to conduct as TikTok, as ByteDance. And that's a punishment by any reasonable understanding of what would be a legislative punishment, right? It's not the death penalty for a murderer. It's not that kind of thing because we're talking about corporate forms here, but it is a punishment. The court, however, does not agree. TikTok contends the act satisfies the historical test because it bars TikTok from its chosen business. TikTok reasons the prohibitions of the act are close analogs to two categories of legislative action historically regarded as bills of attainder: confiscation of property and legislative bars to participation in a specific employment or profession. Yes, they are accusing the U.S. government of essentially extorting them to lose their business, lose their assets by virtue of this particular law. According to TikTok, the act effectively requires TikTok to relinquish its property or see it rendered useless, and it precludes TikTok from continuing to participate in a legitimate business enterprise. As already explained, however, the act requires a divestiture, that is a sale, not a confiscation, as a condition of continuing to operate in the United States. And I find this argument to be wanting, politely. If I were to come up to your house and say, you have to sell this house right now, then you would not be otherwise limited in your ability to claim that I was extorting you, that I was trying to steal the value of your house in some important way, just by the fact that I'm not personally stealing the house from you, not taking the money from you, that you're getting it from another person. Everybody knows that if you are forced to sell when you don't want to, you're going to get lower value for what your asset is in the market because you aren't deciding when you are receiving enough value to actually give up your asset, whether that's your house or your business. And so I think that it's just a divestiture, not a confiscation, is a very limited kind of argument to be made by the court. But they find it compelling, and I am not a judge in the district court. I'm not a judge on the Court of Appeals or the Supreme Court. So I'm just a guy here talking on YouTube. I'm just telling you that I don't find this argument to be very effective. The court did. The closer historical analog to the act is a line of business restriction, which does not come within the historical meaning of a legislative punishment. And they have some precedents on that. The Bill of Attainder clause tolerates statutes that, in pursuit of legitimate goals such as public safety or economic regulation, prevent companies from engaging in particular kinds of business or particular combinations of business endeavors. And so they say, essentially, this is an ownership kind of complaint. We are allowed to regulate who owns you. We are unhappy with the fact that China owns you. So this is not a Bill of Attainder. It's not a punishment on those grounds. They also pass the functional test, basically that they are not specifically just trying to punish you. They're trying to accomplish something else. In this case, they're trying to accomplish national security or data protection. And because we're also going to find as part of this decision that they meet strict scrutiny standards for First Amendment complaints, we are obviously going to find that this passes the functional test here. Finally, they say that we can't use the motivational test because given the obvious restraints on the usefulness of legislative history, congressional intent to punish is difficult to establish. Indeed, the motivational test is not determinative in the absence of unmistakable evidence of punitive intent. So the court says, we're throwing our hands up on your motivations to pass this law because we couldn't possibly know that. Now, one might ask the question based on this language, how did this become part of the test as it stands? The court is not going to answer that for us, but suffice it to say, they're going to say that this particular law, which prohibits anybody from helping TikTok as named in this particular law, despite the fact that the president has not separately found them to be a security concern because Congress has, to not be a bill of attainder. I disagree with that argument, but that's how it was decided before it headed up to the Supreme Court. And if you follow the TikTok story, you know that the Supreme Court did not otherwise declare this law to be unconstitutional either. And in so doing, they did it on the basis of it not violating the First Amendment. Now, I thought the First Amendment claim was already a weak one because this particular law was not strictly aimed specifically at the speech of TikTok, the speech of ByteDance, the speech of any of these companies that might otherwise fall under this act's purview, but instead was particularly focused on the ownership kind of consideration. That's different from it being a bill of attainder. That's different from naming TikTok and ByteDance. But I always thought this was a weak argument. But it's important to know from our legal perspective that the bill of attainder argument, those arguments that I thought were the strongest, did not make it up past the appeals court level. You have to pick your battles when you're asking the Supreme Court to look at your questions. And the Supreme Court was always going to be more compelled by a First Amendment consideration. So that's what TikTok brought before it. And the Supreme Court did not, in deciding that this law was constitutional, otherwise opine on the bill of attainder or takings clause arguments that TikTok brought before the lower courts. I also wanted to read for you just a little bit of the history of this particular case because I think it's interesting in respect to President Trump, which is going to be a major factor in the rest of this conversation. In recent years, says the Supreme Court of the United States, U.S. government officials have taken repeated actions to address national security concerns regarding the relationship between China and TikTok. In August of 2020, President Trump issued an executive order finding that the spread in the United States of mobile applications developed and owned by companies in China continues to threaten the national security, foreign policy, and economy of the United States. President Trump determined that TikTok raised particular concerns, noting that the platform automatically captures vast swaths of information from its users and is susceptible to being used to further the interests of the Chinese government. The president invoked his authority under the International Emergency Economic Powers Act, IEPA. You've heard me reference that in respect to Tencent and Virtual Legality very recently, as well as in other contexts for both this Trump executive order we're discussing right here and in the past, IEPA and the National Emergencies Act to prohibit certain transactions involving ByteDance or its subsidiaries as identified by the Secretary of Commerce. The Secretary published a list of prohibited transactions in September 2020. Federal courts enjoined the prohibitions before they took effect, finding that they exceeded the executive branch's authority under IEPA. Just days after issuing his initial executive order, President Trump ordered ByteDance Limited to divest all interests and rights in any property used to enable or support ByteDance's operation of the TikTok application in the United States, along with any data obtained or derived from U.S. TikTok users. ByteDance and TikTok filed suit in the D.C. Circuit, challenging the constitutionality of the order. In February of 2021, the D.C. Circuit placed the case in abeyance to permit the Biden administration to review the matter and to enable the parties to negotiate a non-divestiture remedy that would address the government's national security concerns. You might remember all of this, but I think it's a useful summary of what happened with respect to TikTok. Throughout 2021 and 2022, the Biden administration, ByteDance negotiated with executive branch officials to develop a national security agreement that would resolve these concerns. Executive branch officials ultimately determined, however, that ByteDance's proposed agreement did not adequately mitigate the risks posed to U.S. national security interests. Negotiations stalled and the parties never finalized an agreement. Against this backdrop, Congress enacted the Protecting Americans from Foreign Adversary Controlled Applications Act, and the act makes it unlawful for an entity to provide certain services to distribute, maintain, or update an application like TikTok. Entities that violate this prohibition are subject to civil enforcement and hefty monetary penalties. The Act provides two means by which an application may be designated an application of this sort. First, the Act expressly designates any application that is operated by ByteDance or TikTok, or any subsidiary thereof. Second, the Act establishes a general designation framework for any application that is operated by a covered company, controlled by a foreign adversary, and determined by the president to present a significant threat. In broad terms, the Act defines covered company to include a company that operates an application that enables users to generate, share, and view content and has more than 1 million monthly active users, and excludes from the definition a company that operates an application whose primary purpose is to allow users to post product reviews, business reviews, or travel information reviews. And this particular aspect is one of the ways that TikTok tried to fight this law, to say that it was content-focused. The worst thing that you can do under the First Amendment in the United States is pass a law that specifically prohibits a given type of content, right? You aren't allowed to pass a law that says, thou shalt not say good things about the country of China. Thou shalt not say good things about the Microsoft Corporation, or bad things. Either way, you can't speak specifically to the content. You have to do these facially neutral kind of laws. And in this case, Congress has aimed it specifically at the company on the notion, at least in some of the legislative record, that they aren't happy with some of the stories and the way the algorithm works for TikTok or ByteDance, but on a security basis, that they aren't happy with the way that China controls access to the algorithm and could easily change it tomorrow to be even worse than it is right now. The Act's prohibitions take effect 270 days after an application is designated a foreign adversary controlled application. And that date that it took effect is January 19th, 2025, a day after this opinion is actually written by the Supreme Court. The Act exempts a foreign adversary controlled application from the prohibitions if the application undergoes a qualified divestiture. We'll talk about that more in just a minute, but there are ways in which you can get out of the operation of this act if you are selling your company. That was the design that was hopefully, from the Congressional standpoint, to get ByteDance and TikTok to sell their interests in the application and more specifically the algorithm so that there wouldn't be this security concern hanging over Congress's head. And in this particular decision, the Supreme Court ultimately determines that the First Amendment isn't implicated. The law goes into effect, and then, well, it stops being into effect. From backing a ban to being hailed as a savior, inside Trump's TikTok shift, as reported by the Associated Press a few weeks ago now, January 19th, 2025. During his first term as president, as we just heard described by the Supreme Court, Donald Trump led the effort to ban TikTok, the hugely popular video sharing site he said posed a threat to U.S. national security. But on the eve of his return to the White House, the president-elect is being hailed as the app's savior. After going dark for users this weekend, Trump said on his social media site that he would issue an executive order after he's sworn in for a second term on Monday, delaying a TikTok ban so that we can make a deal to protect our national security. Thanks for your patience and support, read the announcement from TikTok. As a result of President Trump's efforts, TikTok is back on in the U.S. So if you were on TikTok, or you were otherwise following this story on social media on January 19th of this year, you saw it be taken down, you saw Apple restrict access to TikTok, and then you saw a note from TikTok saying, we're back, thanks to President Trump. And that's part and policy of politics, right? That's what President Trump is trying to achieve here. But it was an interesting question for folks looking at this particular story. That's what happened on the 19th. And then, as promised, on the 20th, as NPR reports here, Trump signs an executive order to pause TikTok ban and provide immunity to tech firms. Now, we don't have to take NPR's word for it. We can actually look at the order itself. And that order is called the Application of Protecting Americans from Foreign Adversary Controlled Applications Act to TikTok. Now, that's an interesting, really long-form way of describing this, since the act itself includes TikTok in its language. But suffice to say, this order, which is an order of the executive branch, it's the president saying, this is what I would like my executive branch, my agencies, my people to do with respect to this law, says the following. The act regulates foreign adversary controlled applications, specifically those operated by TikTok and any other subsidiary of its China-based parent company, ByteDance, on national security grounds. Section 2A of the act prohibits entities from distributing, maintaining, or updating certain defined foreign adversary controlled applications within the territory. We talked about this. Under Section 2A of the act, the prohibitions take place and become effective on January 19th, 2025. President Trump says, I have the unique constitutional responsibility for the national security of the United States, the conduct of foreign policy, and other vital executive functions. So here you can see what he's trying to do in this particular order is say the executive is vested with the control of foreign relations. And so I'm going to claim that authority in this document. To fulfill those responsibilities, I intend to consult with my advisors, including the heads of relevant departments and agencies, on the national security concerns posed by TikTok, and to pursue a resolution that protects national security while saving a platform used by 170 million Americans. My administration must also review sensitive intelligence related to those concerns and evaluate the sufficiency of mitigation measures TikTok has taken to date. The unfortunate timing of Section 2A of the Act, one day before I took office as the 47th President of the United States, interferes with my ability to assess the national security and foreign policy implications of the Act's prohibitions before they take effect. Now, understand, the law does not have a role for the president in deciding whether or not an application run by ByteDance or TikTok falls under this category. Remember, they are named parties in this law. So this is already kind of stealing a base that the president is doing right here. That's going to be part of this story as we continue through with this video. This timing also interferes with my ability to negotiate a resolution to avoid an abrupt shutdown of the TikTok platform while addressing national security concerns. Accordingly, I'm instructing the Attorney General not to take any action to enforce the act for a period of 75 days from today. I hereby order the Attorney General not to take any action on behalf of the United States to enforce the act for 75 days from the date of this order to permit my administration an opportunity to determine the appropriate course of action with respect to TikTok. During this period, The Department of Justice, that's an executive branch agency, shall take no action to enforce the act or impose any penalties against any entity for any non-compliance with the act. So we've got a law, it's on the books, it's written by Congress, it's signed by the president, it is upheld by the Supreme Court, and the new administration, the new president comes in and says, I'm not going to enforce that law for a time. Not because I think it's unconstitutional, but because I don't feel like I have a good understanding of this particular situation, and so I'm not going to enforce it. I'm going to tell my Attorney General not to enforce it. The problem with that, as President Trump has undoubtedly already become aware, is that he takes an oath to defend the Constitution, and part of the presidential powers are that he shall take care that the laws be faithfully executed. This is the take care clause. If you've ever read the U.S. Constitution, this is what the president does. I just described the legislative as writing the laws and the president as executing them or enforcing them. The president is supposed to enforce basically every law. And this is an argument, this is a discussion about what that means in practice as written by the Constitution Center. I'm not going to take a policy position on this one way or the other, but you can see that there's a lot of debate as to what this particular clause, very short but very important, means in practice. At the same time, the provision serves as a major limitation on his power because it underscores that the executive is under a duty to faithfully execute the laws of Congress and not disregard them. At a minimum, the clause means that the president may neither breach federal law nor order his or her subordinates to do so, for defiance cannot be considered faithful execution. So if we look at the law, we see that the enforcement mechanism is the Attorney General finding there to be a problem and imposing the fines that are set forth in the law. The president has within his branch, the Attorney General and the Department of Justice, he tells them not to do that. Is that faithful execution of the laws? I certainly have questions there. But the clause raises a number of vexing questions. For instance, must the president enforce those laws he or she believes to be unconstitutional? Some scholars argue that presidents must enforce all congressional laws without regard to his or her own constitutional opinions. I would disagree with that very significantly. As I just said, the president and Congress both have to take oaths to defend the Constitution, and Congress shouldn't be passing unconstitutional laws, but the president shouldn't be enforcing them if he believes them to be unconstitutional. Now, in this particular case, the Supreme Court has held that this law is not a violation of the First Amendment. Could be a violation of something else not raised before the Supreme Court. Either way, it's determined to be constitutional for purposes of legal argument right this second. So the president really doesn't have those grounds to stand on. There's also the related question of whether the president must honor statutes that purport to limit his or her authority over law execution. Can Congress decree by statute that the president must allow others to implement certain statutes without regard to presidential supervision or oversight? Now, we see in the definition in this law that most of the categories of who could be impacted by this law are to be determined by the president or his branch in general through interagency discussion, except for applications that are made by TikTok or ByteDance. So I think there is an argument here that at least says that Congress is trying to usurp the power of execution, the power of the presidency, by including as maybe not a bill of attainder, but a named party in this particular law outside of the broad ambit of who is otherwise going to be impacted by it. But that isn't raised in the executive order either. Finally, the sweep of contemporary federal law ensures that federal law enforcers have tremendous enforcement discretion. And this is really what comes up most in the modern presidential era. In particular, resource constraints coupled with numerous violations often preclude a policy of total enforcement. Said another way, we have so many laws on the books and so much that the president or the Attorney General or the Department of Justice or the FTC or the SEC or whoever you're thinking of could enforce, that there is no possible way that they could enforce every violation against every violator. So there's already some amount of discretion that is within the executive branch because they don't have the resources to impose penalties or other impacts on every violator of federal laws. Now, you can argue that's not a great place to be. I would certainly be sympathetic to that argument, but it does mean that even with the take care clause in effect, the executive branch and the presidency in particular has the right to make certain policy determinations as to where the resources should go, what laws need to be most enforced over others, what we might call, if you're familiar with sports terms in the United States, a point of emphasis. We are going to instruct our agencies or whatever aspects of the executive branch are implicated to focus on these particular laws, these particular violations, and put our money and our resources there. And that might cause other laws to go by the wayside, but that's the purview of the executive branch. None of that is implicated here, but it's important to understand that that's a problem for President Trump because the law actually does have a concept of penalties, who enforces them, the Attorney General, as we just discussed, and what you might do to extend the time frame of the ban, to give more time for TikTok and ByteDance to operate. And that is to say, Congress said, with respect to a foreign adversary-controlled application, TikTok, the president may grant a one-time extension of not more than 90 days with respect to the date on which this subsection would otherwise apply if the president certifies to Congress that A, a path to executing a qualified divestiture, a sale, has been identified with respect to such application, B, evidence of significant progress towards executing such qualified divestiture has been produced with respect to such application, and, so all of these need to apply, he needs to certify all of this to Congress, that there are in place the relevant binding legal agreements to enable execution of such qualified divestiture during the period of such extension. So, Congress has said, all right, there might be an issue with this timing. We understand this might come up, Mr. President. You get one time to extend it for 90 days. And if you decide to extend it for 90 days, then you have to certify to us. You need to make a report to us that all these things are in place, that you're on your way to a sale, that there is significant progress towards that sale, and that we can enter into a closing document. We can actually execute this sale within the 90 days that we are willing to extend this time frame of. But you might recall, in that executive order, we didn't see a 90-day time frame. We saw a 75-day time frame. That's outside the purview of the law entirely. And it is in respect of the Attorney General not enforcing these particular penalty provisions. Nothing to do with whether there's a qualified divestiture, which leads us to Trump's problem. Can Trump put a pause on the TikTok ban? Or as the Associated Press says, since an extension on a ban can only occur if significant progress has been made towards a sale, it's possible that Trump's order could face legal challenges. In fact, we would anticipate it. On Sunday, Senator Tom Cotton of Arkansas posted a message on X listing a number of state and federal agencies and private entities that might be willing to go to court to get the ban enforced. However, it's unclear if anyone is planning to challenge Trump's order. One thing that happens in the law, and I know we talk about it a lot in Virtual Legality on a realpolitik basis, is that if no one's willing to fight over this, chances are you can do whatever you want from a government role. If you're not going to challenge a law as unconstitutional, Congress can pass that law, can enforce that law. And if it's not challenged, then the court doesn't get to say anything on it. In this particular case, if you sign an executive order and there's a legal problem that nobody decides to challenge, we'll never know if there was a real legal problem because nobody decided to challenge it. So we don't know whether it would be challenged, but if somebody wanted to challenge it, it would be on the basis that Trump does not have the ability to just say, no, I'm just going to ignore that law entirely. I'm going to tell my entire branch to ignore that law for a period of time that was designated by me outside of any of the times stated in the law. And if you do challenge me, chances are what you're going to say is that you have to prove that we are moving close to a sale. So as I just mentioned, Trump brushes off TikTok national security concerns while calling for a 50% deal, as reported by the ABC News, is a function of that particular conversation. It's Trump, outside of his executive order, trying to say that he's still acting within the purview of the law, because to do otherwise would be to violate his constitutional oath. Or as he says in the quote in this article, TikTok is worthless. Worthless if I don't approve it, it has to close. I learned that from the people that own it. If I don't do the deal, it's worthless. Worth noting, if I do the deal, it's worth maybe $1 trillion. $1 trillion, Trump said. He continued to argue that there should be at least 50% U.S. ownership of the app, although he didn't make mention of the national security that prompted the app's ban in the first place. Trump notably called for a ban on the app due to national security during his first term. If I do the deal for the United States, then I think we should get half. In other words, wait, I think the U.S. should be entitled to get half of TikTok. And congratulations, TikTok has a good partner. And that would be worth, could be $500 billion US or something. And again, if you look at these quotes and think, wow, this sounds like a shakedown. This sounds like a U.S. government extortion scheme on whatever the asset value of TikTok is, I'm not going to blame you. But as part of this story, Trump's got a problem. Trump thinks TikTok is worth something. Trump thinks that if they're going to legally challenge him on this executive order, that he needs to have somebody ready to buy the company, or at least willing to say that they could buy the company. You wind up with an article like this one, or a statement from Trump like this one that says Microsoft is in talks to acquire TikTok, right? So my supposition here, and again, it's just that, it's just speculation on my part, is that Microsoft is one of the few companies in the United States, indeed it's one of the few companies on earth, that could plausibly say at the level that Trump is talking about that we have the cash or other assets that we could purchase this particular company. And as part of that $3.07 trillion market capitalization, they can also be obsequious to the new incoming administration. We know from our experience with the Microsoft Corporation, covering it in this context and just watching it in the news and otherwise, that they have as their chosen political approach in things like regulatory review of deals that they have made in video games and otherwise in the past, that they want to be as positive as possible towards the governments that are regulating them. They do not want to be seen as an antagonist. They want to be seen as a fellow traveler to these particular governments. And that is well within their rights as a corporation or otherwise to do. But we know this about them. And if you're President Trump and you're looking at a potential legal challenge to this particular issue, you don't want to lose that, then it behooves you to suggest that one of the few companies that could actually buy an application the size of TikTok is willing to do so, if that company is otherwise as obsequious as they are. And this is an article that I pulled up that I was doing while I was reviewing this video that says from Microsoft on AI that as we usher in a new year, we will welcome a new president into the White House, as well as a golden opportunity for American technology and economic competitiveness. And again, this is not a political statement here. This is not super unusual for corporations that take this approach, but it is worth noting that Microsoft, this huge multi-trillion-dollar corporation, has throughout all of these conversations we've had in Virtual Legality now for years, taken the tack that we are going to buddy up with whatever the administration is doing at that point in time in United States history. And so it makes all the sense in the world to me, looking at this particular issue, that when they say things like in sum, as we look to the 4 years ahead, there are many reasons to be optimistic, that they are a chosen vessel through which President Trump and his administration can say, look, we're moving forward with a potential TikTok sale. If anybody wants to challenge me on this, I can defend, not just because he might be able to do that because Microsoft actually is engaged in these conversations, but also to actually knock down the possibility of people challenging him on the legal grounds we just talked about. Because if there is somebody that could potentially buy this company within the next 90 days, then that legal challenge is likely to fail in any event. So people asked me to talk about this particular story. I saw it in the news a couple of days ago. And the very first thing I thought was that Microsoft in particular, and Brad Smith, their VP of government relations specifically, is in the business of buddying up to administrations, is in the business of making friends with governments for purposes of benefiting the Microsoft Corporation and being able to use the Microsoft name. I don't think President Trump would have done it without permission, is useful to him for purposes of this particular conversation. So I wanted to frame that for you in that way as part of this talk, because I think TikTok is one of the biggest, most interesting stories of the year. I think Microsoft is always interesting and worth talking about because they are so big and have their hands in so many pies in the United States and globally, but also because I thought there was a lot of misinformation out there in the world and that it is more useful to go through the source material, look at the laws, look at what's actually being demanded of the president, what the executive order actually says, and how Microsoft can play a part in this particular story with you all today. Now, that's Virtual Legality for today. If you like this video, if you want to support the channel financially or otherwise, please consider becoming a member of the channel. We're going to do more membership early videos like this one, super chats on live videos, Patreon. You might notice if you've been here a number of times that I have removed Player and Utreon from the support systems for this channel, primarily because in looking at my activities after my stroke a couple of years ago, I've determined that I am incapable or unable to actually support both platforms at once. So if you do support us on Player right now, please consider coming over to Patreon or through YouTube directly and memberships. Otherwise, nobody should feel obligated to support us financially at all. I appreciate every little bit of help, whether that comes as financial support or just subscriptions, upvotes, comments. I try to respond to as many comments as I can on this channel, or just telling your friends that we're having conversations like this one. If you find them helpful, if you find them useful, informative, educational, entertaining, what have you, tell your friends. We love to have people here. I love to have the community talking about these particular issues so that we can have good, reasonable conversations about things that might be very, very different approaches from different people in our comments. I very much appreciate all of that support. Otherwise, those questions and comments are ones that I see very, very often, and I try to respond as much as I possibly can. So
Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.